Following program does not have a normal intro because I was really too busy smoothing other things over to get it done. So, Ori? Good evening, everybody. Welcome to the following program. I am your host, Joe Neerman, a.k.a. Good Lawgic. So glad that you could join me on this fine evening, or if you're watching me tomorrow during the day, this fine morning, this fine afternoon. Now I'm starting to feel like the Truman Show. Okay, so lots to cover. We did not yet get a decision as to whether or not Judge McAfee is going to allow Fani Willis and or Nathan Wade to remain in the Georgia RICO case that is presently pending against Donald Trump, Mark Roman, countless other people. And when I say countless, I mean it's impossible to count. We are expecting that to come sometime tomorrow. Very, very much looking forward to that dropping. Maybe it comes in the morning. There's all sorts of rumors going on that a decision was supposedly uploaded. Something was happening with that. There was talk about that. That it was trying to be uploaded, and maybe that certain attorneys have been called down to Judge McAfee's chambers to talk to the judge about the ramifications of this order. I've seen all sorts of different things here. There was a guy, Black Insurrectionist, who was talking about that somewhere. In fact, let me just pull up what he says about it. I don't know if this guy has any insight. These tweets have been going on all day today. Yeah, where is this? DocNet, where are you? DocNet YouTube. There's this guy. Here's this guy. Go down a bit smaller so I can see it. You don't see what I'm looking at. I know. I'll give it to you right now. Check this out. This is what I'm looking at right now. This Black Insurrectionist. These are the first things. He kept saying breaking all day. I don't know if this is true. I don't know if it's not true. It hasn't been spread around a lot. As you can see, how many hearts does this have? He claims his source is Fulton County Clerk. Breaking Judge McAfee has written 2 different drafts of the Fani Willis case. He doesn't spell Fanny properly. One draft has been disqualifying Willis due to appearance and conflict. The other draft is non-disqualification that will allow the Trump team to appeal, which would delay the case past Election Day. Sounds very strange. I don't know. Do you swallow this? Are you swallowing any of this? Is this making sense? Rumble's not working. Is Rumble working for y'all? It is working. Okay, we're good. We're good in Rumble. All right, so the draft on non-disqualification will have approval for appeal, which is why both are wins for Trump. Everything has approval for appeal. You wouldn't need approval for appeal. I don't understand what that means. If he decides against the defense, whoever loses, even if you lose in part, you can appeal. So that part doesn't really make sense to me. He claims he called Steve Sado's office. They cannot confirm or deny there's a meeting conference going on now reviewing the decision. I don't know. People were sharing this with me. Then we got this. Fani Willis' decision has been made. Odyssey electronic record system in Georgia is down, according to Fulton County. System is back up. The order should be entered. Calls to merchants say that have not been returned. What do you guys think? Excuse me. This is the proper CV number, not for the criminal one, 188947, 23 SC 188947. I've been frustrated with that site in general. So I don't know. I don't know if it's been uploaded or what the hell is happening with it, but that was the news I was getting. We spent a lot of time talking about it, and no one seems to be paying much mind to it. But I stumbled on you. I stumbled on you, DocNet YouTube. I stumbled on you. So should I do anything with that? Oh, you're saying an interlocutory, which does require permission from the judge. See, Thad sounds like an attorney, because that's something an attorney would say. And that's true. An interlocutory would basically say that if there is some sort of ability for him to appeal, that he's basically saying if there is an appeal, that would put this on hold. Now, that wouldn't that makes sense. That makes sense. You're an attorney, Thad? Are you? Are you? I didn't think of that, and that's a really good answer. Because normally when you have a criminal proceeding, if you lose as a defendant and the case is marching forward, you might say, hey, I don't want to go to trial until this is decided, and you would need the judge's approval to put it on hold. And what he's basically saying is that at least baked into this cake would be an ability for him to appeal. Now, I'll tell you this much. He should appeal. I don't think he'll win on the appeal. It's unlikely he'll win on appeal because so much of this is findings of fact. And if the judge is the ultimate determinant of determiner of findings of fact. And if the judge says that my findings of fact do not support, unless he lays out these are the facts I found, and I don't think that reaches a level of knocking her out for lack of appearance of impropriety, maybe it seems very unlikely to be overturned on appeal. I think it's very, very unlikely. So that's one thing that's been reported out there. But there's other issues that Fani Willis is facing, far more potentially significant issues, which could threaten her entire political future. Republicans are threatening to go after Fani Willis. And we're going to look at that, whether or not they're going to hold her in contempt. Let me just get this real quick before I do that. What do you got here? Did you see Megyn Kelly interview today with Dersh on her channel about 6 hours ago? They both think the signs point to McAfee not dismissing Fani or the case. VidTile begins new revelations. Did I see that? Did I see that? I want to show you something. I want to show you something, sir. In case you're wondering if I saw that. I did see it. I did see it. Not only did I see it, I actually thought about calling it out. Look at this. Look at this, my friend. See the little red line here? I watched this all the way through. All the way through. I was getting very annoyed at Dershowitz. You want me to break this down before I get into Congress? I can do that. Let's do that real quick.
Paul Sperry, he gets a lot of scoops. We've had him on the show before. He does these deep investigations for Real Clear. And he's sent out a couple tweets citing a source close to the judge. Now, we don't know whether this person actually is in a position to know what the judge is thinking. But the second tweet, we brought the first one to our audience last week. The second Paul Sperry tweet reads as follows. Judge McAfee views cell phone data and the Terrence Bradley texts as suggestive, but not dispositive, or as enough proof to settle the matter, according to an Atlanta attorney familiar with his thinking. Texts provide no insight into how Terrence Bradley would know, meaning that they had an affair long before 2022.
I don't know why Terrence Bradley has to know. They alone should be evidence.
Did he see them? Wade told him.
Who cares?
Now that.
Who cares? The point, even if he never saw him texting ever in his life, if they're there, that's the issue. It's the 12,000 texts that's funky.
Is an interesting thought that the judge is getting ready to dismiss evidence of the cell phone data, the many texts between these two long before they admit their affair took place, and the middle of the night visits, as the texts seem to suggest, and so on. And also Bradley's texts to Nathan Wade, or to Ashley Merchant, saying, it began well before, because he's saying the texts don't actually show Bradley had personal knowledge of it. Could have been speculation. Well, if any of that is true, how do you see it?
That's just dead wrong. There are people on death row. I have a client in prison on far, far less compelling evidence of pings and tweets and cell towers. She put people in prison based on that. If this judge doesn't conclude,
everyone does. Everyone puts them in jail for that. Everyone.
Beyond any doubt that there was an improper relationship. Also, is there any doubt that she never paid back the money? What lawyer who has to comply with ethics rules would ever not have a record of paying back money? You have bank deposits, withdrawals, you have a photograph of the money being paid. But for her to make up a story that she paid the money back and has one piece of evidence that once she paid for a wine tasting with cash, there are so many people in prison for long term on less evidence than that.
Much less evidence. This part I agree with.
Judge doesn't believe that, or says he doesn't believe it. He wouldn't be telling the truth. I can tell you with 100% certainty that this judge sitting there knows absolutely that this affair occurred before, that the money wasn't paid back, that they committed perjury, that they conspired to commit perjury.
If it was not a district attorney, for sure anyone would come to it. If it was not a district attorney, there'd be no hesitation. If it was someone who's not politically connected, there'd be no hesitation in saying, obviously, she had a relationship with him that predates the contract of November 1st, 2021. The fact that she's a district attorney shouldn't change that at all.
But judges sometimes pretend that they don't believe testimony or believe testimony in order to spare themselves. He doesn't want to look the elected DA in the eye and say, you're a perjurer, you should be in prison. But there's absolutely no doubt that there's enough here to disqualify. And if he doesn't disqualify, this whole case will be subject to all kinds of criticism, not only in the court of public opinion, but in the courts of law as well. I hope the judge does the right thing, but I've said from the beginning, I don't think he will. I don't think he has the guts.
Yeah.
I don't think he has the courage.
What the hell do you know about this guy? What do you know about him? He had the courage to have this evidentiary hearing. He could have just said, I don't think there's enough here. So this is the part where he starts getting into his own speculation. And I'm like, did you ever hear this judge before this case brought to him? Doubtful. He's only been a judge for less than a year. So I'm sure you never heard of this guy before. What do you know about his courage? What do you know about any of this? I don't know. This is the part to me. I said this last night. Someone predicting what he's going to do and says, oh, yeah, this is what's going to happen. They're grifting you. They're grifting you. And I'm sorry, Dersh, this is wrong. This is wrong. You don't know anything about this judge. Nothing. You know nothing about this judge. I've seen indicia from him, which lead me to have some level of hope. But every time I say it, I caution it with this is just indications. I don't know. Maybe he is a coward. That's possible. Why make this speculation?
To tell the truth. And I think he'll find a way to weasel out of this thing to say, oh, well, the cell tower, who are you going to believe? Me or your lying eyes? Look, she and he had an affair before they were appointed. That is absolutely clear. And her testimony under oath is perjury. The evidence is overwhelming as to that. And if the judge pretends not to believe it, there's a bridge in Brooklyn that I could sell him as well. But
he didn't write or indicate anything of the kind so far. Nothing. And he's sitting here saying he's gonna cower.
Judges do that all the time. Cops arrest
That's
people.
True. That's true. We do see judges do that all the time, but you're judging him based on the group. This is exactly everything you stand against. Judging an individual based on the actions of a group are exactly everything he's made his whole criminal defense career about. And now he's judging this judge based on what he's seen from other judges. You don't know this.
Say the drug dealer dropped the drugs on the floor. That's lie number 7 on the list of 10 lies. Dropsy testimony. And I've looked in the eyes of judges and they say, well, we believe this testimony. And then, 2 years later, after court, you talk to the judge and they'll say, of course, I never believed it. Of course, I knew he was lying, but the person was guilty and I just didn't want the person to get off. Judges play that game all the time. And if this judge tries to play that game now, a lot of lawyers and a lot of people like you and me are going to be after him because it will be a disgrace to the judicial system if she's allowed to continue. It's a disgrace to the legal system if she's not disbarred and not put in jail. And I hope the people of Fulton County have enough sense to throw her out of office, at least when it comes to an election.
All right, a couple of questions on that. Could the judge, because I do want to talk about what import we glean from the dismissal of those 6 counts. I mean, but let me just table that for 1 second. Table it for 1 second and ask you, do you think there's a way in which this judge could say, I'm not going to kick her off this case. I'm not going to maybe even kick Nathan Wade off the case, though I think, most people agree he's probably gone. But let's say he says, I'm not going to kick them off the case. Any disciplinary matters involving their misleading of this court really are a matter for the bar. And so I don't approve of it. I don't like it, but I don't see as grounds for disqualification. This is really just an ethical matter for the bar.
He could say that. That would be a cop-out, but he could say that. And also, I think his dismissal of the 6 counts basically was a message. See, I'm fair. I don't rule in favor of her every time. I took that dismissal of the 6 counts as a signal that he was not going to disqualify the whole office. Otherwise, he would have waited to see whether the new office was going to stand by that or maybe re-indict. So
that's why would you take it as that signal when we know that this will go to the Special Prosecutor's Council, in which case it's going to be assigned to another judge. And once that happens, he has no more control over prior decisions. So he would be leaving this out in nowhere. I walked through this yesterday. There's a really logical reason for him to take care of a prior motion before handling this motion. And that is that if he, and that would be consistent with him dismissing Fani from this case. Because if he dismisses Fani from this case, as soon as he does that, this case goes into cold storage indefinitely and almost certainly will not end up in his courtroom ever again. So it makes sense for him to say, before I issue a decision, which is putting it into cold storage because I'm removing Fani Willis, I'm going to make a decision on these issues so that in case his case is resurrected by another judge, it is reassigned elsewhere, that this issue will already be put to bed, that these charges are not sufficient and cannot stand against Trump or the 6 charges in general against these defendants. So that is a very logical reason why he would take care of it. That's actually something that you would hope he would take care of beforehand. And that's what I'm saying is he's saying I'm taking from this a cue that he's trying to throw a bone to Trump in order so this way he won't look as bad when he rejects the motion regarding Fani Willis. I think that's so speculative, and he has no reason to know that what his perspective on it is more accurate than my perspective. And I'm not saying that's even my perspective. I'm not saying that's what I believe is the case. What I'm saying is that's a logical reason for him to do it. And he has no reason to pick A over B, but he's just jumping into this because he seems to have perhaps, and not without justification, to be fair, he seems to have a perspective that every judge is political. But that's exactly the sort of thing he's constantly railing against. And that's why I'm saying, okay, now he's on Megyn Kelly and he's coming out here basically, railing against this. So, it becomes an exciting news clip that people end up super chatting me and saying, did you see what Dershowitz said? And I'm not saying nothing wrong with Ed super chatting that to me. That was a perfectly normal and proper thing to bring to my attention. My point is it's trying to make headlines. That's what I think Dershowitz is doing here.
I think that your source is probably correct. And I think it was Levin on Fox News who called me the Nostradamus of lawyers.
Oh, stop blowing your own horn.
Because I get my predictions right all the time because I don't make
all the time
predictions based on wishful thinking.
Well, you're making it now not on wishful thinking. You're making, I think, on a cynicism of the court. I don't think it's wishful. I think you want her gone. I just think it's a cynicism of the court, and you're applying that. You're attaching that to this individual judge, which I think is inappropriate.
So my prediction here is that he's going to figure out a way of not completely and totally disqualifying them. Maybe he'll say there's an appearance, but the appearance isn't enough under the law. But whatever he says, if he suggests that you can believe anything she said, he should not be on the bench because he would not be telling the truth. He does not believe her. I guarantee you, he's smart enough. Do you know anybody who actually, even CNN, many of their legal commentators who were always wrong say they didn't believe her. They didn't believe him. It's not enough here to disqualify, but we don't believe her. If you don't believe her, she's committed perjury. And if you don't believe both of them, they've committed perjury, obstruction of justice, and conspiracy to commit perjury. Again, let me emphasize one more time. She put people in prison on less evidence than is now against her. What hypocrisy.
All right. So the judge issues this decision dismissing 6 counts of the indictment. I agree. My first instinct when I saw it was...
And I agree, by the way, that she's a hypocrite. I agree she's a total hypocrite, an arrogant hypocrite. But his conclusions as to where this is going to go is just... And
he's trying to show I did something that was good for Trump. And then maybe later this week, he's going to say, and I did something that was good for Trump's prosecutor by keeping Fani Willis on the case.
And I understand people coming to that conclusion. I understand people coming to the conclusion of exactly what Megyn Kelly is saying here, that, you know, he's trying to appease both sides, which is what cowards do. That is what cowards do. I understand that that's possible, that it's motivated by cowardice. I'm simply saying, what is the evidence that we should judge? So far, the only evidence I've seen from him is that he has a backbone. And that evidence is that he conducted this evidentiary hearing, because most judges would not have.
I think we can probably glean he's definitely not going to grant the motion to dismiss this case entirely because of Fani's alleged conflict.
And I'm not sure that it should be dismissed entirely. As looking at it from a legal matter, I mean, I think it should be dismissed because I think the whole RICO charges are ridiculous. But as far as because of her taint, I don't think that that's a reason to say that this case has. That to me, it doesn't make sense. In other words, to say just because the mouthpiece here is twisted and contorted towards fabrication, that doesn't mean that the charges that are coming out of the mouthpiece are impossible to be true. So, you know, if it wasn't Trump in this case, whenever I'm trying to assess these things, I'm going to come back to this. Whenever I try to assess these things, I try like take out this particular individual. I'm trying to come philosophically to what makes sense, right? So if it wasn't that this was a prosecution of Trump, but this was a prosecution of, I don't know, Darrell Brooks for driving a car through a parade, would I want these charges dismissed just because the mouthpiece is completely twisted and sick? No, obviously not. And it doesn't mean that the guy's innocent. So I can understand him saying, I'm not going to just throw these charges in the garbage, but I will take it away from this twisted mouthpiece. So I don't think philosophically, while I think there's a lot of problems with the whole thing in general, I think that he should be, I think specifically Trump has immunity, like because he was acting under presidential privilege in the ambit of his role as president. So that's the reason to throw it out, not because the mouthpiece which brought these charges is thoroughly twisted.
Because why else would he be reducing 6 counts from it? Yeah. Okay. So that's not. I don't think the case is not going to go away.
Yeah.
All right. So that's that.
He agrees with me on that.
Here's another thing that we found this soundbite from the judge speaking with the local radio station last week, and he was being asked, Alan, about his new left-wing challenger to his judge seat, which he's now got to run for re-election on. He was unchallenged, and then at the last minute.
I'm not comparing the charges, JM. I'm only bringing you up here because I'm afraid that there'll be someone else who would draw this conclusion from what I just said. I'm not comparing the charges. My point is that if you're approaching something from a philosophical perspective, you have to sort of ask yourself, what would I say in this other extremely different case? That's my point. These charges are not remotely comparable. Like I said, I don't think it's legal. I think even if he doesn't have immunity. Even if the court were to reject immunity, I think it's illegal for a state to hold a president to a state law. To me, he's above state law. I don't think he should be subject to that. Certainly, if he's acting within the ambit of his role as president. How ridiculous is it that every president is now governed by 50 different state laws plus the DC laws? That doesn't make any sense at all. So to say that I think that there's so many reasons that this is, aside from the fact that I think everything he did was proper, but I think that conceptually it makes no sense. There are so many problems with this charge. I can't even begin to number them, okay? I think these charges are bogus, stupid, crap, political persecution. As opposed to Darrell Brooks, who I think is satanic and should be burning in the depths of hell forever. I want to draw a point philosophically. I need to say, okay, what is proper for a judge to do? So I have this case here where we have a political persecution, which never should have been brought in the first place. And then there's other case here where there's no level of punishment we can give Dow Brooks, which is sufficient to meet to meet what I think would be actual justice. So whatever standard we're saying as far as how I want a judge to rule with the district attorney, that standard has to apply in both of them. That's why I'm comparing them, because they're so disparately different from each other. I hope that's clearer now.
This guy who's from the Rainbow Push Jesse Jackson coalition throws his hat in the ring, and he's now challenging him from the left. And he was asked about that and how, if at all, it might weigh on his decision over Fani. And here's what he said.
I had a rough draft and an outline before I ever heard a rumor that someone wanted to run for this position. So the result is not going to change because of politics. I am calling it as best.
Grifty says he said he had an outline rough draft on before opponent announced, before closing. This is a local. He sent me this on local. It's pretty funny. It's pretty funny. Like, we're just literally hearing the judge say in his own voice what Grifty is telling us that he said. His mind can already be made up that they're out even without closing arguments. If he doesn't disqualify, but it's on record saying he had draft done before closing, it looks like he's in the bag. I think that what he said was he had a rough draft and opinion drawn before he had a political opponent in his race to be reelected as judge, not before closing arguments. That's what he said. But if he doesn't disqualify, but is on record saying he had draft done before closing, he didn't say before closing. In fact, I'm going to go back like 5 seconds so we can hear exactly what he says.
Asked about that and how, if at all, it might weigh on his decision over Fani. And here's what he said.
I had a rough draft and an outline before I ever heard a rumor that someone wanted to run for this position. So the result is not going to change because of politics. I am calling it as best I can in the law as I understand it.
Okay. Yeah. Now, my very smart law school friend who listens to the show every day, she's a lawyer like you and I are. And
she's in law school. Oh, she was from when you were in law school. Oh, okay.
And she says she thinks from that, and I think she's got a good point. The only reason he would remind us that he had drafted a decision.
No, it wasn't. No, it wasn't. No, it was not. You're mistaken about that, my friend. That the opponent was only discovered, that political rainbow, that rainbow coalition guy, that was in the week after. In the week after. Because I remember people speculating to me, like on Saturday night, the closing was on Friday, and on Saturday night, I think, or that the reason he's waiting 2 weeks is to see if anyone runs against him. No one heard of this guy beforehand.
Before he got the challenge from the left would be if he's about to rule that Fani can stay on the case, because he wouldn't need to reassure us that he had drafted anything to, deal with a competitor if it was going to be against Fani, right? Like, he wouldn't draft an opinion getting rid of Fani in order to appease the left.
Wrong.
So I think she might be onto something there, that statement may have telegraphed he's about to rule in favor of Fani Willis staying on.
And you can read it the exact opposite way also, though. You could read it as, because a lot of people speculate that guy joining in there is a motivation for him to try to punish Fani if he thinks Fanny's behind it.
The case. What do you think?
I agree with that. I think all the signs point in that direction, and all the law and the facts point in the opposite direction. But I don't think this judge is going to do justice in this case. I think he is going to figure out a way of not having her disqualified. Look.
Oh, I think he's going to do justice. Okay. I think he's going to do justice. I think he's going to do justice.
The worst.
What about Nathan Wade, though? What about Nathan? Yeah, I know you won't go as far as say Fani in the office, but what about Nathan Wade?
That's easy. He could say, look, the appearance of justice, I recommend strongly that he be taken off the case so that the appearance of injustice.
I'm positive he's getting rid of Wade. I'd be shocked if he does not get rid of Wade. I'd be shocked. I wouldn't be shocked if I'm wrong about the whole Fani thing. I think that's what I think, and when I'm saying I think that, I'm telling you I definitely do not know that. I'm not saying that with conviction, saying my gut is leaning toward he's gonna get rid of Fani. That's what my gut says. But only because the facts and evidence are so strong, and he does seem to have enough of a backbone to do it. So I think Dershowitz is wrong here. That doesn't mean I'm right. I'm not telling you for sure that's what's happening, because I'm telling you right now, I definitely don't know. It's like, gun to my head. If I had to predict the future, I'll tell you this is what I think is he's shown enough cojones that he's not gonna cower to the politics. The only indication that we have, the only indication that anyone can point to that really shows me that he might cower, and this, if he had said this, I would have a lot more respect for Dershowitz that he's rooting his opinion on this, would be as follows: that when Fani was on the stand, he seemed to show her a great deal of deference and latitude that he would not show he likely would not show to most other witnesses. That would be a point to say, you see, he's afraid of Fani. That would be a point. That's the only reason that I question his backbone. That he basically let her run the courtroom while she was in the witness stand. And that gives me pause in saying he's going to have enough of a backbone to pull the trigger and drop the hammer on her. But I think, and I agree that if he allows Fani to stay, that's cowering. It's cowering. It's cowardice. I agree with that. Now, sometimes it might be that he has cowardice and doesn't even recognize that it's cowardice. But Dershowitz coming out here that he's positive the judge is going to let Fani stay and railing against the judge for this at this stage, that's crazy to me.
Disappears. That would be an easy call for him, but it would have no impact on the case. Look, the worst thing that ever happened to American judicial system is election of judges, election of prosecutors. We're the only country in the world, in the Western world, that elects judges and prosecutors. And the politics obviously play a role in all of these decisions. So, but I agree with your friend. I think she's very insightful. That that statement suggests that he is not going to rule in favor of Donald Trump on the disqualification. Again, that's my judgment. I don't have enough to make a.
He has a reason to say that, no matter what, no matter which way he's going. This is why I think people are desperately trying to figure out, read the tea leaves on him. I mean, I'll tell you something. It's so amazing how the entire world is waiting with bated breath for his decision here. I mean, waiting with bated breath. This is it's like, ooh, you can picture Viva Fry with his finger tapping, excitedly, here it comes, ooh. But like I said, this is like when we're waiting for the Depp decision. This is like when we're waiting for the Rittenhouse decision, and we're like, come on, give us what we want.
Firm prediction, but I hope he rules the other way, but I often predict against my own wishes. So that's my prediction.
All right. Yeah. So let's get ahead of ourselves a bit and say he keeps her on the case, irrespective of what happens with Nathan Wade, that he keeps Fani Willis on the case. What happens as a realistic matter in now her prosecution against Donald Trump and these defendants, now that the whole nation has had quite an introduction to this woman and her ethical bar?
Well, first of all, it becomes a big appellate issue. Second of all, good trial lawyers could try to figure out a way of getting her credibility somehow in front of the jury. It's not an easy thing to do.
It sounds like a very difficult thing to
do. But the American public does not believe Fani Willis. They don't believe she's a truth teller. And
how do you? I'm just trying to. That's something I would love to sit him down and say, how would you? Because this judge has shown a scrupulousness about trying to keep out things that are irrelevant. When you're talking about these charges, trying to defend on the basis that you can't bring up directly saying that, well, he's innocent because Fani's a liar. That seems wholly irrelevant. This seems like a very, very tough challenge for any trial attorney to try figuring out how to try and keep hammering that in front of a jury, when we can expect that McAfee is going to say that that's irrelevant. how do you create relevance out of that? It's going to be really, really hard to just keep pounding her about this, especially when she's not even going to be in the room much of the time. It'll probably be some other attorneys, like, I don't know, Adam Abadi or someone else.
If I'm a defense attorney, I try to take as much advantage of that in every single context, both the trial and on appeal. So she's become a big issue now in this case.
I agree it's possible. It's possible that if you could figure out a way to do it, I'm sitting here, I'm struggling trying to figure out how would you do that. You have to expect that McAfee's going to be like, let's assuming that he's correct, I'm wrong. Fani stays on the case. Now the case is marching forward. We're coming to a jury, and I'm sitting here, and I want this jury to know just how corrupt the DA's office is. And if she's not a judge to have committed perjury, so you can't even throw that out here. I guess, I mean, look, historically, what he did in his Simpson defense was he was continually attacking the police force in the way that they did their investigations. And I guess you can try and raise this as the investigations that were conducted. This is how okay, I'm just totally speculating here. And this is something, if I was actually defense for Trump or any of these defendants here, that I certainly agree with Dershowitz, that you want to throw this in front of a jury. So let's think about how you do this. Well, we saw in the Simpson trial that they basically put Mark Furman on trial. In case you were too young to appreciate the O.J. Simpson trial, when it was a criminal trial, which was live streamed for months. Mark Furman, who was the lead investigator for the police, they kept basically attacking his methodology for the investigation that he did. With respect to this particular case, arguably, I mean, the investigation that they did, to the extent that Nathan Wade was involved in it, you can try and draw in, I guess, that he was involved in this investigation process, and he's someone who is corrupt in the sense that we see he's lied on his own interrogatories and try and bring evidence of that to try and show his lack of trustworthiness. You would need some latitude from the court to have that be admissible and not be deemed irrelevant, because the state would be screaming irrelevant, 403, objection, relevance over and over again if you try raising up anything about Nathan Wade. The only way you could try to circumvent that is to say, look, this entire investigation was done corruptly, and the corrupt nature of these individuals, that he was willing to perjure himself and he's an attorney who's willing to perjure himself. What's one way, I guess, that you could, I'm just brainstorming right now how I would try to get, that wouldn't attack Fani Willis, it would really be more of an attack on Nathan Wade, to bring up this hearing. You can then, I guess, if that doorway is open, that would open the Pandora's box to start talking about all the other illicit statements, illicit claims that were made during the course of this evidentiary hearing relating to relationship that they had, and that this entire office is corrupt. Perhaps that would be something that if I was Trump, I would be looking for express permission on that and say, you want to allow these corrupt people to move forward with this prosecution? I want to be able to point out that they're motivated by corruption. And that's something that they can bring an application for. And that's something that if you lose on that, that's something you appeal, that you have the right to introduce their corruption at trial. That's how you do that. And you basically threaten the judge that, look, they obviously are acting corruptly. You don't want to, you say there's no appearance of impropriety. I'm going to keep throwing this impropriety in everyone's face throughout this entire trial. That's how you do it, I guess. That's a good idea. That's good trial tactic. That's good trial strategy. Let me get to a couple. I want to get to a couple of these chats. Haley, I want to tell you this. Joe, I love watching you. I hate paying Susan. You hate checking Venmo. You missed 4 out of my last messages. How should I bug you without bugging you? I want to tell everyone here this. Okay, Haley here is awesome. I mean, awesome. This young woman here has sent me so many Venmos. I can't even tell you. I did a search. I would show you my search results here for Haley. I just don't want to dox her by giving out her last name because I get notifications in my email. Okay, so I don't want to dox her by giving out her last name. But she is so many times she will throw a question at me or a comment or really even not even something that she's looking for me to respond to, and I feel so guilty. In fact, I'm gonna drop. This is for you, Haley. That's for the. I'm gonna give you another one because so many countless times that you just like kicked money out to me just as a show. Love and support, and usually not with like often without even a question. It's just a matter of like just expressing appreciation. So before I'll just go to this, I'll work backwards on a handful of these. Haley says Ethan Crumbley mom doesn't know, she's guilty. Ethan Crumbley's dad doesn't know, guilty. Ethan Crumbley friend knows, so he goes scot-free. The school goes scot-free. Why is Crumbley able to be tried as an adult, but the only friend who actually knew what was up his sleeve isn't even charged with tampering? Same with school. It's heartbreaking. Yeah, it is heartbreaking because they're punishing two-way people. That's what this is about. I couldn't even cover the trial of the dad because, frankly, after I saw the trial of the mom and I realized that the dad had more control over the gun than the mom did, I was like, if the mom's found guilty, the dad is cooked. I knew he was cooked. I was like, I'm going to get angry and depressed watching this. So I was like, I can't watch this. I can't watch this because this is watching a train wreck. And I agree with you. I agree with you wholeheartedly. Once you're charging him as an adult, for the parents to be considered culpable makes no sense to me. Makes no sense to me. And why is the school not charged? Because they're not the gun owner. Just said, Schaefer must have been Terrence Bradley's attorney. I do not recall. That's pretty funny. She was also asking me why was Hannah able to chill at home during her trial, but neither of Ethan's parents were. I don't know what happened at their bail hearings. I think that they probably used the fact that they purportedly ran as a basis to say to deny bail. Although I'm not sure if bail was denied, it was just set a very high number. So that likely weighed in on it. I'm gonna go to the last one was a $20 Venmo she sent. She also asked me two questions. She said, hey, I'm just catching up. And part two questions. One, would the state be required to pay back the attorney's fees if Fani's kicked off the case? Definitely not. You never have to pay back the attorney's fees. Two, does the judge consider there's zero chance that she would be able to offer a fair and impartial trial after this debacle? That's what Dershowitz. See, you're saying what Dershowitz was just saying. Is he going to consider it? I don't know if he's going to consider it. I think he's going by the whole appearance and party stake. So, and before that, there was a $50 super chat. Just so many times that she gets me. So I just want to publicly acknowledge how much I appreciate you, Haley. Thank you so very, very much for your constant support of the show. He's ruling on the motions in order. Yeah, we got this. Charles Vance, new member of the following. Now, when you become a member of the following, that makes you a follower. A lot of people mistakenly believe that this means that you become a follower of me. But that's not the truth because I'm not the leader of the following. The following is just a group that cares about community and unity and greater personal growth. So I welcome you to that group, Charles Vance, as you are a valued member of the following. And I thank you so much for joining. And I just want to caution you that while you're here in the following, some people will try to troll you into thinking that the following is like some kind of cult or something like that. I'm here to reassure you that the following is not at all a cult type of cult. And there's no spaceships, no Kool-Aid, no mandatory tracksuits, no self-harm, no harming others, no squirrel mutilations, no goat sacrifices, no throwing blood on the walls, no self-harm, no stabbing yourself with a jabby jab, no snorting ashes, no throwing virgins in volcanoes. It's not at all a cult type of cult. Not at all a cult type of cult. So welcome to the following. And again, I'm not the leader. I'm just a follower, just like you. Joe, is it possible that Fani had any persuasion during the 2020 election of any kind? It's possible Fani had any persuasion during persuasion. You mean like, in the ballot box? Ballot box persuasion? Anything's possible. What do I know? Oh, you're saying that she herself was being persuasive in who was going to win the 2020 election in Georgia. I don't know. That sounds highly speculative. I would not go out that. I would not go on that road. Please don't mention Fani's taint again. Gross. She's got so much taint. I checked locals. We got that. You need more characters. Grifty, you were fine with characters. You were fine. The opponent was known on the day of closing. That's so not true. Not true. Pat D says the Bradley text and Cell Hawk data are separate, and then there's Yurdi, bank records, etc., which all point in the same direction. If he denies motion, it'll likely be based on law, not facts. I'll tell you right now. If he denies this motion, it's based on cowardice. Okay? That's all. It's based on cowardice, and Dershowitz will be right. I doubt courage features prominently in Allen's life. Yeah, probably not. Is the motion to disqualify appealable? Yes. Any motion that is brought here is appealable. At any trial court level, a motion is appealable. What people were speculating about in the beginning of this show is whether if he might say I'll allow an interlocutory appeal, which would basically mean I'm putting the case on hold. Normally, a criminal case is not going to be put on hold while the appeals are going on. That this would be put on hold. That either he's going to dismiss Fani or that he's going to put the case on hold while it's appealed. But I think that would be a loss for Trump, because I think it'll be a win in that this trial will not go to trial. This trial will not come to a jury until after the election. It would be a loss in the sense that it'd be a loss in the sense that he would lose on appeal. Well, I think almost certainly. It'd be very, very unlikely he would win on appeal, because so much it would be based on determinations of fact. And if he reaches a conclusion of law, that means he's going to claim that his findings of fact are likely not very strong in favor of Trump, meaning that he agrees with a lot of the crap that Fani sold. So that's why I think that Trump and his co-defense would likely lose almost any appeal that would come up. One way it could come is if Anna Cross were to do the cross. That's true. She can screw up a lot. Perhaps coordinating with Biden is corrupt. I think so. Didn't seem like the judge was interested in hearing any of that. Has Trump brought up presidential immunity? If it's already before the Supreme Court presidential immunity. So if the Supreme Court says it's presidential immunity, I think that would have great impact on this case. If SCOTUS agrees with him, it would not knock out simply the DC case before Chutkin, but it would have a significant impact on this case also. Would it knock out this case altogether? For Trump, probably. I would think so. For the others, probably not. The headline will be Judge McAfee exonerates Fani. Well, that would be a typo, because McAfee is spelled with two E's on the end. But no, it may be. I don't. The 8 for Horns. One more chat regarding Fani after the EC one. Oh, there was another one. Was there another one? Did I miss that? Let me refresh. See if I missed anything. I think I got it. I covered you. We're good. Okay. And Fani has so much taint, she hired 3 men to clear. Well done. All right. Anyhow, as I said, I don't really like what he did, Dershowitz, in this thing, because to me it felt as if he's trying to make a headline by saying he knows what the judge is going to do, and it's like 50-50 that he's right. And then he tries to sort of start walking it back at the very end of it. The very end of it, you'll see here, he does a little tiny walk back. He spent 11 minutes so far here.
If she had been smart, she just would have recused herself. Not the office, just recused herself and recused him and said, this is bigger than both of us. Let's get on with this. But she has an enormous ego. The fact that she volunteered the testimony and bolted into the courtroom and began to tell what I regard as lie after lie after lie shows, I think, what kind of a person she is. And I would not be proud of that.
Financial experts thought we were in the clear. They were anticipating around 6 rate cuts by the Fed.
Oh, I missed it. But at some point he said, I could be wrong, but, you know. Yeah. Sorry, Megan. You do good work, but I'm not slinging hash for you. All right. So that right there is the assessment of Fani, but the Republicans in Congress have issues with Fani as well. They got issues with Fani as well. And we need to break that down because she could be facing contempt charges, and this ties in to issues that that Salty brought up as far as coordination with Biden. Check this out. Check this out. Today, House Judiciary Committee Chairman Jim Jordan sent a letter to Fulton County District Attorney Fani Willis threatening to begin contempt of Congress proceedings for Willis failure to comply with the committee's subpoena and document requests. Dun, dun, dun. The committee issued a subpoena on February 2nd, 2024, after several attempts to obtain voluntary compliance. Subpoena compelled the production of 2 specific categories of documents. Number 1, documents and communications relating to the Fulton County District Attorney's Office. And their receipt and use of federal funds. And 2, documents and communications relating to any allegations of the misuse of federal funds by Fulton County District Attorney Office. While Willis produced a narrow set of documents on February 23rd, 2024, full compliance with the subpoena to date has been deficient. She has not produced any of the following categories of documents. What is missing from what Fani was supposed to be sending? But she hasn't produced any where they asked for all documents and communications referring to relating to any allegations of the misuse of federal funds by Fulton County District Attorney Office. I'm just going to say Fulton County from now on. All documents or communications between or among the Fulton County, the DA office, and the Justice Department, including its OJP and OVW components. OJP and OVW components. The Office of... Oh, come on. What is that? What is OVW? We're going to check that out. I want to see. Office of Justice Programs is the OJP, and OVW. No. Yeah, I don't know what OVW is. Did they tell us what it was? I don't know what that is. If I don't know, I can say I don't know. One of you know? God bless you. All communications between FCDAO employees about the receipt of use of federal grants, and all documents that fall within the scope of the subpoena, such as the district attorney's applications, proposal abstracts, grant agreements, financial management system internal controls questionnaire, and consolidated budgets summary documents. Let's get to the full letter. Let's just do that right now. Let's get to that. 3-page letter. We can knock this thing out. From Congress, the United States, to the Honorable Fani T. Willis. The reason they send a letter like this is because if you're ever going after someone and then you have a follow-up communication and you're like, what's happening? You have documented that they are now aware of their failure to comply, and it's that much more incriminating against them. So that's a reason that you would send a letter like this. It sort of sets you up to bring criminal charges where you might, to obtain a ruling of contempt. Dear Miss Willis, the Committee on the Judiciary is continuing its oversight of the Fulton County District Attorney's Office receipt and use of federal grant funds issued by the DOJ. On February 2nd, 2024, after several attempts to obtain your voluntary compliance with oversight, the committee issued a subpoena to you. The subpoena compelled the production of 2 separate kinds of documents and communications referring to and relating to the district attorney's receipt and use of federal funds, and documents, communications referring to relating to any allegations of misuse of the federal funds. On February 23rd, 2024, you responded, but we think your response was crap. You gave us a letter in which you smeared a former employee of yours who spoke out about the misuse of federal grant funds. We will not dignify your attacks on this brave whistleblower. We're not going to dignify that with a response or your continued attempts to distract from your conduct through misdirection and personal insults. We are wise to you and your tactics, where you're blaming everyone else for your misdirection, your personal, from your misdeeds. The allegations in the public realm about your misuse of federal grant funding are concerning, and the committee has an obligation to examine them. We appreciate that you have produced a narrow set of documents. The reason they say this is like, we don't want anyone to think that, we're misleading. There was a narrow set of documents you gave in response to the subpoena, but your compliance with the subject date, the subpoena to date, is deficient. Attached to your letter were various documents, a number of which we previously produced to the committee that contained, among other things, 15 award letters from the Department of Justice, where you're self-aggrandizing yourself with your award letters for the DOJ's Office of Justice Program and Office of Violence Against Women. You see, I saw that when I was looking up the OVW, and I was like, what does that have to do with anything? I did this quick search over here. I was trying to figure out what the heck is OVW. And I'm like, Ohio Valley Wrestling? I saw this Office on Violence Against Women. I'm like, what does that have to do with misuse of federal funds? OVW Wrestling? I was like, I don't want to bet that it's violence against women, but I guess that makes sense here in this context. All right. And approximately 27 screenshots of expense budget summaries available to the district attorney's office. However, you failed to produce any of the following categories of documents. And they list them. What is she missing? She's missing all the communications and documents related to any allegations of the misuse of federal funds, meaning like emails, things of that nature, people complaining that, like, why are you misusing funds? Or any documents that show that misuse. All documents, communications relating or among your office and the Justice Department, including its OJP and OVW components. All communications between district attorney employees about the receipt or use of federal grants, where they basically were like, we're going to be using this money to go get us some glam. Oh, yeah. Time for the fashizzy. We're going to be buying us some vehicles. Oh, yeah. I get me a new desktop. All documents that fall within the scope of the subpoena. I use that tone and that accent, by the way, because that is, I assume that there's obviously in Fulton County District Attorney's Office that there's an unusually high number of Russians working in that office, and that was my best Russian accent right there. All documents that fall within the scope of the subpoena, such as the District Attorney Office applications, proposals, abstracts, grant agreements, financial management and system of internal controls, questionnaire, and consolidated budget summary documents. So these are. And finally, all documents, communications relating to the District Attorney Office, grant performance measurement and progress reporting information. So all these 5 different categories, we got nothing. We got nothing from these 5 categories, and we find that to be deficient. Although additional materials are likely also responsive, so we might have missed some stuff to the committee subpoena, as an accommodation, we will prioritize the production of the documents and communication identified above. So there's probably a lot of other stuff that we're entitled to get based on that subpoena. But that's where we want you to fix this if you're going to try and remedy this situation, which we strongly recommend that you do. Your letter also requests that the committee engage with the Justice Department to obtain responsive documents that the District Attorney Office should have in its possession. So you're basically saying, stop asking me as the DOJ for this. As a part of our oversight, committee has engaged with the Justice Department about its administration of federal grant programs. We're a step ahead of you there. I don't need you to tell me where to go look, Fani. We already know where to go look. Thank you very much. The committee's separate requests to the Justice Department do not alleviate your legal obligation to comply with the subpoena. So whatever they give us got nothing to do with you. You have your duties. They have their duties. You have your duties. Whatever they do does not alleviate your responsibility under the subpoena. Smart answer. Makes sense. In addition, in your letter, you noted preliminary objections to the committee's subpoena on the grounds that the subpoena is overly broad, unduly burdensome under any ordinary meaning of those terms. That, by the way, is a common way that attorneys will try and deflect from demands being made of them, that they refer to as being overly broad and unduly burdensome. or they'll say documents already in your possession. I know this because I've engaged in discovery for the last 25 years. So I've both seen it and done it. That you say overly broad and unduly burdensome. I'm not saying I've done it in any way illicitly. God forbid, I never would. I'm simply saying I've seen people say that to me. And there are times it's overly broad and unduly burdensome. To the contrary, the committee has exercised authority with restraint. The subpoena seeks only 2 categories of documents, and the scope of its request covers only a limited time period. I'm not asking you to go back to I'm not to the creation of Fulton County. We're going back to January 1, 2020 to the present. We got 3 years worth of stuff there. In addition, as discussed above, the committee is prioritizing certain categories of documents as an accommodation. We're trying to make it easier for you. We're not trying to be unduly burdensome. We're trying to limit the time and the nature of the documents we're asking for. That's what Congress is telling Fani Willis here. While you have indicated that additional documents may be forthcoming in response to the committee's subpoena, which basically means I might just, when you write that, she likely meant, if I'm in the mood to, I'll send you documents in the future, which means I'm never going to think about this again unless you bother me. That's kind of like Jen Psaki saying, I'm going to circle back to you. All that good stuff. That's what, if she said that the documents may be forthcoming, that whenever someone says documents may be forthcoming, that means the committee has yet to receive any additional responsive materials in the 3 weeks since your initial response. So we're starting to take it that you weren't very serious when you said that they may be forthcoming. Accordingly, the committee expects that you will produce all responsive documents to subpoena in the categories prioritized by the committee no later than 12 p.m. on March 28, 2024. If you fail to do so, the committee will consider taking further action such as the invocation of contempt of Congress proceedings. There you go. So give us what we need by March 28th. And if you don't, we're going to take further steps, which may include contempt of Congress proceedings. You might say, why are they only considering it? Why are they only considering it? Why don't they just say, if you don't, we will begin contempt of Congress proceedings? This is a circumstance, unlike when someone says that documents may be forthcoming, when they say we will consider taking further action, almost always it means we will. And this will happen in the future. As an attorney, you learn to read between the lines as to when a may is a genuinely, oh, maybe it will, probably, definitely, almost definitely not, as opposed to we will consider, which means we almost definitely will. But I don't want to promise that I am, because I don't know what's going to happen. I mean, something might happen. I'll get in the way of it. But this means that Jim Jordan's planning on doing this as of right now, and that he feels he needs to give her, legally needs to give her some fair warning. So that's the fair warning that, yeah, you don't do this, and we're going to be looking at contempt. That's what we're looking at. And he sees the Honorable Gerald L. Nadler, ranking member, who sat there and basically threw his coffee cup across the room when he saw this letter, saying, "These effing publicans going after our knight in shining armor who's trying to take down Trump. This is purely political prosecution, that they're trying to just protect Donald Trump." Whatever stupid thing he's saying. Gerald Nadler. Looked like the penguin. All right. So there you go. There you go. That is what Fani is dealing with now. She's dealing with Congress saying, we're going to hold you in contempt because we think you're abusing your federal funds. She's likely to kick out some documents. The most likely thing is she'll kick out a smattering of documents in order to say, I complied. But that probably won't be enough that as to what Jim Jordan is looking for. I'm just telling you how these things work. This is how you sort of try to pull the teeth. And you see how loose the tooth comes when you send out a letter like this. And that's what Jim Jordan was doing. And you were right. Offers the violence against women. There you go. Do you think Nathan Wade should be given immunity for sleeping with Fani for only 6 These are fair questions for deeper minds than my own. Sorry to say, but given the Biden DOJ, Congress is impotent to enforce a subpoena. Looks like Jim Jordan will be another one emasculated by Fani. I don't see that. I don't see that. They have their own. They have their own task force they can send down there to arrest her. You don't need the DOJ to hold her in contempt. Congress itself can hold someone in contempt. That's some of the powers of Congress. Some of the wonderful powers of Congress is that they have the ability to do that. Get their sergeant arms down there. Mary is me says, are you going to cover the oral argument Supreme Court on Monday morning? It's a free speech big tech issue. What we got going on Monday? I'm going to have to check SCOTUS blog. What we got on SCOTUS blog? Sorry, I'm checking out. I'm checking this out. What we got? Surgeon General of Missouri and Murthy versus Murthy, Surgeon General versus Missouri. I need to look at it. I need to look at it. And by the way, just to let you know, Elliot is sharing with me and locals that there was a motion to dismiss in Georgia based on presidential immunity. So I was pretty sure there had been a motion. I appreciate you calling that to my attention. I'm not going to pull that up now. You think they'll investigate the New York AG next? I don't know. It's Murthy versus Missouri, Missouri v. Biden. That's Missouri v. Biden? That's Missouri v. Biden? Why is it Murthy versus Missouri? Is that really true? Are you sure about that? Because Missouri v. Biden, I definitely would cover. Is that this morphed into that because when it came to like actually effectuating it, it came down to Murthy? I gotta look into this. I gotta check this out. All right, let me get likely. I'll tell you right now to answer your question. Likely, Mary is me that I will cover it. Not promising, but likely. I want to move forward though because there's other stuff. There's a lot of stuff to cover here. Lots of stuff to cover. All right. Alvin Bragg. That's next up on the list. I'm saving the juicy, funny one, which is going to be Don Lemon being fired again. Saving that for last because I think that's a phenomenal story to close out the week on. Because that story I think is going to be. I haven't even gone through it, and I'm sure it's going to make me laugh. Ever noticed Nella looks like Stay Puft Marshmallow Man? Time to cross the streams. Did I see your fly boy? What do you mean? Your ads? I don't remember seeing it. Judge Joe Brown was on the Real Danish show. They talked about Judge McAfee rules in Fani's favor. It may not be a bad thing. Yeah. See, I don't know that Judge Joe Brown. And I know that he can be pretty base sometimes. I don't really look at him as like an intellectual guru. Now, he could offer up some perspectives. I'm not really a huge fan of Joe Brown. No offense to Joe Brown. I'm just like, okay. He might be great. Maybe I'm selling him short. From the limited amounts I've heard of him, I've been like, not feeling it. Not feeling it. But that's just a personal thing. Is this the right one? Make sure. Here we go. So today, Alvin Bragg basically tried bending the knee to Donald Trump and filed this. People's notice regarding production of records from the U.S. Attorney's Office consent to adjournment. Defendant Donald Trump. This is in the New York case, the New York criminal trial against Trump for his purported attempt to use his business records to conceal a crime. That's what he's charged with in New York. And I have noted that this is a very weird type of charge to bring because the crime is not a state crime, it's a federal crime, and you're using a state charge saying you cannot use your business records and change your business records to go after a federal crime. But the reason for the state law is to help ensure that people are not going to be breaking state laws. So it's a little weird how he used this, and it's never been used in that way before. So that's part of the criticism I have of this case. Another part of the criticism I have of this case is it's kind of stupid to say a president should be subject to state law. But in this context, it's not really within the ambit of his presidency. I don't want to go down that road right now, though. Let's look at what's happening here with now that we know the case we're talking about here. Let's focus on what Bragg did today. I've been telling you all how eager I've been for March 25th. March 25th, start of the trial in New York. I'm going to be down in New York March 25th. I told everyone March 25th. I know where I'm going to be. I'm either going to be live streaming if it's available to the public, or I'm going to be going down to New York myself. Well, because in case you're unaware of it, I live 11 miles from the courthouse, as the crow flies. Which 11 miles in New York traffic language means like an hour and a half from the courthouse. It really is so sad during rush hour. It's like an hour and a half. So, all right. Well, where were we? Defendants move for an adjournment or dismissal based on claimed discovery violations. Also seeks to adjourn the start of the trial by 90 days because of the production since March 4, 2024 of approximately 73,000 pages of records by the United States Attorney Office. These records were produced in response to the defendant's January 18, 2024 subpoena to that office. So on January 18th, Trump's lawyers sent a subpoena, and they ended up getting back 73,000 pages. The people's opposition to the defendant's motion is currently due tomorrow, March 15th. So if we're going to oppose it, we have to submit our opposition by tomorrow. The people's opposition will set out in detail our full compliance with Article 245 throughout the discovery process in this case. We submit this notice in advance of that opposition to advise the court of additional developments yesterday. So what happened yesterday? After the defendant filed his motion and the people submitted our one-page letter response. Specifically, yesterday, the U.S. Attorney Office produced approximately 31,000 pages of additional records and represented there will be another production documents by next week. So that's I'm at 104,000 so far with more to come. Based on our initial review of yesterday's production, those records appear to contain materials related to the subject matter of this case, including materials that the people requested from the U.S. Attorney's Office more than a year ago, and the U.S. Attorney's Office previously declined to provide. So we got another, who knows how many pages are coming. These developments do not affect the people's compliance with the obligations under Article 245. We did what we're supposed to do. The people of the state of New York did what they're supposed to do. It's the United States government, their attorneys. They're the ones who failed to turn this over. Why are they making demands from the United States Attorney's Office? Because there was a whole investigation to see whether he was engaged in election fraud and what he did there and under federal law. And it seems as if the U.S. Attorney's Office said, there's no crime here. It's not a crime what he did, which that is a big part of Trump's defense here. It's a big part of Trump's defense. Think about this for a second. This is what's so stupid about this New York trial. Arguably, under federal election law, so you're obligated to put notifications with respect to monies that you spend. So what they're saying is that the hush money that he gave to Stormy Daniels, that should have been noted as a campaign contribution. Okay, so I'm going to break this down a little bit more detail, even though I haven't looked at it in roughly a year. But I feel confident that I have enough recollection as to the facts of this case that I can break it down for you in summation here in under 2 minutes in a way that you will understand. So all the way back in 2016, prior to the election, he paid money to Stormy Daniels and had her sign a non-disclosure agreement. Basically what people call a hush payment. Hush up about the nature of the relationship, which, to be objective, likely involved some sort of sexual congress there, just given what we know so far, but may not have. We don't know that for sure. But whatever it is, there's nothing illegal about that. That's totally fine. He's allowed to pay her money to keep her mouth shut. There's no crime in that. The left loves portraying this as like his hush money payments as if that's a crime. People pay hush money all the time. I mean, seriously, there's a slush fund of millions of dollars in Congress that they have to help each other out in hush money payments. It's not a crime. You might say it should be a crime. You might think it should be a crime, but it's definitely not a crime. People look at it as being scandalous, salacious, whatever you want to call it, whatever you want to call it. At the end of the day, it's not a crime. So what are they saying is a crime? They're saying that when he gives money to her, that is helping his campaign. And since it's helping his campaign, it has to be noted as a contribution to his campaign. But he didn't note it as a contribution to his campaign. So that is a election campaign, potentially a federal crime, if they're correct, that it's properly deemed a contribution to the campaign. So let's say he gives, I don't know, $200,000 to Stormy Daniels, that's a $200,000 donation to his campaign. So in that case, now that could be a crime if you don't properly report donations in your campaign. It's a federal crime. Has been charged with violating the federal law by the United States District Attorney's Office? No, because they're not so sure it's a crime. They're not so sure there's any crime here at all. Because A, it's kind of weird to call it a campaign contribution, especially since a lot of these monies came after he was elected. You don't even know if he's going to run again when he's filing all this stuff in 2017. You don't know he's going to run again. So to call it campaign contribution is kind of funky. Also, maybe he's paying her hush money, nothing to do with winning elections, but he doesn't want his wife to find out. It's got nothing to do with anything having to do with an election. So to say that, and in order for it to qualify as an election campaign, it's got to be clearly to benefit his election. And this would be his re-election in 2020. Then these are payments he's making in 2017. So it's a campaign donation in 2017 for his 2020 re-election. It's a very thin case. It's a very, very thin case. And the U.S. Attorney's Office said, we're not doing this case. This case is stupid. This is a stupid case. We're not doing it. But they did a lot of investigations, which is why they have hundreds of thousands, $100,000 pages and documents regarding this investigation. Alvin Bragg, New York District Attorney's Office, says, so when he wrote in his own personal business records, and he labeled this as being, I don't know, one thing, and it had to be a different thing, that is keeping business records designed to conceal the election, the federal election crime. But that means there has to be a federal election crime, which the U.S. Attorney's Office seems to feel there ain't. So Bragg is basically saying this record keeping you kept in your own personal logs, never filed anywhere, never shared anywhere. That stuff there, that is right there. Boom. That is a violation of New York state law, that you're keeping business records that are corrupt, that are cookbooks designed to conceal a crime. Now, in the state of New York, it's supposed to be designed to conceal a state crime, not a federal crime, and also not a federal crime that the federal government and the prosecuting attorneys from the federal government seem to think is no crime. That's why we're not even charging you. That's why I'm saying that this case is so cockamamie retarded that you have to be literally out of your mind to think that this is not politically persecuted. And I'm going to try and find some way that I can try and take this thing and reinterpret how New York law is supposed to work, that all it's supposed to be supporting federal crimes, even though it's never been charged ever in New York state history, never been charged that you're trying to conceal a federal crime, and that now you're breaking a state law for trying to conceal a federal crime with your crooked books. That has never been charged before until Alvin Bragg is going after the president of the United States for that. I mean, it's just mind-blowing. Mind-blowing. So, now that we understand a little bit more about the context of this case and what Alvin Bragg is claiming as a basis to try and throw Trump in jail, it's not for making hush money payments. It's that the nature of how he recorded those payments, he's saying is a federal crime, and then under state law, when you kept your books there, you're trying to conceal that federal crime. So now you can understand how all the work done by the U.S. Attorney's Office in looking into whether or not there was a crime, which they ultimately conclude is not a crime, all their work there is very relevant to this case. Because if there's no crime here under federal election law, if the U.S. Attorney's Office is correct that there's no crime here, you can't be trying to conceal a crime that you now get hit with the state law. So in order for Alvin Bragg to win, he needs to show there was a crime, and that this was him trying to conceal it. So whatever documents and work the U.S. Attorney's Office did to investigate that federal election crime is very, very relevant to both the state, to both New York State prosecuting district attorney's office and to Trump in his defense. So you can understand why these documents are not just like, sort of kind of, they are everything about the case. Everything. So with that in mind, I hope that was clear, because I know this is a very confusing, this is probably one of the most confusing charges that he's facing. So that's why I want to walk you through that. So these developments do not affect people's compliance. So what they're saying is we had to turn over documents, and we turned over our documents under Article 245, and certainly do not warrant dismissal. Because if you fail to turn over any documents that are exonerating to a defendant, that could warrant a dismissal. And the people are ready for trial on March 25th. We're ready to go. We're ready to go. U.S. Attorney's Office very slow in turning over their documents. We're ready to go. Nonetheless, in light of the distinctive circumstances described below, which we know you're not going to force him to go to trial when he just got 100,000 pages in documents, still doesn't have all his documents. So you're not going to force him to go to trial in 10 days. The people do not oppose a brief adjournment of up to 30 days permits sufficient time for the defendant to review the USA Attorney Office productions. We're okay with giving him 30 days. The reason he's saying this is because he knows this trial is not going forward on March 25th. Zero chances this case is happening March 25th. Much as it might help Good Lawgic grow to 100,000 subs, if this case were to go forward on March 25th, the reality is it ain't. By the way, while I'm here, check out, while I'm on that topic, because honestly, I care more about justice than about subs, but I'm told I don't do this enough. So look at that. Look at that. Look at that. Oh, look at run. Subscribed. There you go. Little reminder for you. We'll let it play again just because I can. So what I'm saying is Alvin Bragg knows that in fact this is never going to go to trial on March 25th, and that there's going to be an adjournment. So he's trying to say we're okay with 30 days. We're being reasonable. How is the judge going to give only 30 days when we have no idea what documents are coming in? We don't know how many. Another 500,000 pages that are going to come in next week. U.S. Attorney's Office is supposed to be sending more documents next week. You're going to give him all of 30 days? He's getting the 90 days. I'll tell you right now, he's getting the 90 days. Regarding the 73,000 pages of new records by USO, as of the date of defendant's motion, the people's initial review indicated those materials were largely irrelevant to the subject matter of this case. Irrelevant to you, that's nice. With the exception of approximately 172 pages of witness statements that defendant would have adequate time to review and address before trial. That's very, very nice of you to think that they're irrelevant. That 72,000 pages of it are irrelevant. What the hell does that even mean? Yesterday afternoon, however, the USO produced approximately 31,000 pages of additional records to both the people and defense in response to defendant's subpoena, and also indicated that an additional production would follow by next week. We note that the timing of the current production of additional materials from the U.S. Attorney's Office is a function of defendant's own delay. Oh, is it? Okay. The people diligently sought the full grand jury record related to Cohen's campaign finance convictions from the U.S. Attorney's Office last year, including exculpatory material and grand jury minutes and tapes, witness lists, and other documents identifying the names and identities of grand jury witnesses, any grand jury subpoenas and documents returned pursuant to those subpoenas, exhibits presented to the grand jury. These are all things related to Michael Cohen. Michael Cohen was Trump's attorney who was indicted and charged and found guilty of committing perjury. And he was involved in this whole payment plan with Stormy Daniels. So the people sought all the stuff related to exhibits presented to the grand jury to the extent within the scope of Rule 6E, summaries of witness interviews that occurred outside the grand jury, and to the extent within the scope of Rule 6E, search warrant affidavits or other applications that contain evidence from the grand jury and evidence seized pursuant to those warrants. So we made this request for all 6 of these topics right here. We made this requests. And what happened when we made the request? The attorney's office produced a subset materials we requested, which we timely and fully disclosed to the defendant. So we got whatever they sent us. They gave us a subset. Some of that stuff they got to us, and we sent it on to the defendant on June 8, 2023, more than 9 months ago. Despite having access to those materials since June, defendant raised no concern to the people about the sufficiency of our efforts to obtain materials from the U.S. Attorney's Office before last week. Instead, defendant waited until January 18th to subpoena additional materials from the U.S. Attorney's Office and then consented to repeated extensions of the deadline for the U.S. Attorney's Office determination. The timing of the U.S. Attorney's Office productions is a result solely of defendant's delay despite the people's diligence. Really? Really? Nonetheless, and although the people are prepared to proceed to trial on March 25th, we do not oppose an adjournment in an abundance of caution and recognition that you're definitely going to grant it, and to ensure the defendant has sufficient time to review the new materials. We therefore notify the court that we do not oppose a brief adjournment not to exceed 30 days, notwithstanding people's compliance with all our obligations under Article 245. So Alvin Bragg is like, I'm totally fine with pushing this back to April 25th. We also request an extension from Friday, March 15th to Monday, March 18th for the people to file a full response to the defendant's discovery motion. We need more time also. We need more time to put in opposition in order to permit us to fully address intervening developments since the date of defendant's motion. So God only knows what's going to happen with that. We submit this notice before filing our opposition to defendant's motion to make the court aware of yesterday's developments as promptly as possible and to permit the court to consider how to proceed. We're available for conference with the court if the court requests. Respectfully submitted, Alvin Bragg, the Schmuck, by Matthew Colangelo. So there you go. That's what they filed earlier today. I can guarantee you this case is not going to trial March 25th. And it's looking more and more doubtful this will happen before the election. So if you're keeping tabs as to which of these cases, if any, are likely to proceed to trial prior to election, this is what we got. There's 4 criminal cases. This one, which was scheduled and definitely not going to get delayed under any circumstances, swore Alvin Bragg. Definitely happening March 25th, no matter what, for sure, for certain. Alvin Bragg just agreed to push to April 25th and may get pushed back to June 25th. May happen, may go back 90 days. That's number 1. Number 2. Oh my God, I just realized the timing of that. That would be really disastrous. If that actually goes to trial on June 25th, I'm going to... Wow, that's a problem. Okay. It's my own personal thing. I have a trial that's set for June 24th. These continual delays from these other cases make it so hard. All right. Next up. So keeping tabs on where we're at. So you have the New York trial. New York trial now, we don't know when it's happening. It's not going to be before April 25th. And likely, who knows what's going to happen even in 90 days. Who knows? We don't know. That's where we're at there. Then you have the D.C. case. D.C. case is on hold while the Supreme Court is deciding whether or not it's knocked out completely because of presidential immunity. So that's on hold. Then you have the Georgia RICO case, where we don't know if that's going to be permanently shelved because Fani Willis and her indiscretions with Nathan Wade. So that one might be gone altogether. It might go into the abyss. We're going to find out more about that tomorrow as to whether it's going to go into the prosecutorial office counsel, in which case he'll be sitting there on a shelf waiting for some district attorney in the state of Georgia to take interest in it, which may never happen, or it could happen next week. No one knows. And then, so that's case number 3. Case number 4 is the first federal indictment, which was the Mar-a-Lago raid, the documents. So that one, Trump actually took a hit on today. Did not have a decision that he liked. In the case of the United States of America versus Donald Trump, Walter Nauta and Carlos de Oliveira. Before I get to that, let me just cover a couple of these chats that have been waiting out here for me. So, you tell me you want me to check out Judge Joe Brown on the Real Dana Show, 117:30 to 122. Time's it. 11:40. I'm not doing that. I'm not doing that today. Crowder, I appreciate the thought, Chip V, but I'm not on time for that today. Crowder filed an amicus in this is the SCOTUS case on Monday. Oh, cool. Congress can vote contempt, but without DOJ cooperation, it would take a very long time for federal court to actually enforce compelled compliance. Maybe. Maybe. Possibly. Who knows? Who knows? Anna, off topic, but did you see dumbass Schumer's speech on Netanyahu today? No, I did not see that. I did not see that. Sorry. Pay from campaign, bad. Pay from personal, bad. Whichever way he'd filed it, they would say it was bad. It was a catch-22 that they felt they had him in. Federal election, how does state have jurisdiction? I explained, I think I walked you through that since then. So hopefully I walked you through. Context of case, state court found jurisdiction when they had none because Orange Man bad. Yep, there you go. There you go. My prediction, judge will be light on Fani so he doesn't jeopardize his own career. The case won't be thrown out. I think Fani's career is in greater jeopardy than Trump's liberty or the judge's career. But who knows? Is Trump buying that NCAA winning team all those Big Macs a campaign violation? Is Trump buying that NCAA winning team all those Big Macs campaign violation? Or is it only a crime if he bought them McRib sandwiches? That's pretty funny. That's pretty funny. That's what I'm saying. It's so stupid. It's so stupid as far as how you classify something as being a campaign violation versus a campaign contribution versus, I mean, what the hell are you even talking about? It's crazy. 73,000 pages is 20 plus feet of height. I wouldn't be surprised at all. How thick is 1,000 pages? 1,000 pages gotta be. I'm curious about that. How thick is 1,000 pages? put this in 73,000 beats. Why is this not working? Oh, no, this isn't working for me. My paper thickness calculator isn't working. There is a paper thickness calculator, but I don't know how to use this thing. Looks like one of the newfangled calculators I got today. Once you get past square root, I'm done. I'm done. I don't want to see your logarithms. All right, let's get into the developments in the Florida case. Let me make 100% sure I didn't miss anything here. Sometimes I do. I'm good. Okay, I'm good there. I'm good over here. I'm good here. We're good everywhere. Okay. All right. This cause comes before the court upon defendant Trump's motion to dismiss counts 1 through 32 based on unconstitutional vagueness. So we saw how this unconstitutional vagueness, which was called special demurrer, in Trump's case got 6 charges dismissed. So he filed this on February 22nd, 2024. The special counsel filed a response in opposition, to which defendant Trump filed a reply. Court heard argument on the motion on March 14th. Upon careful review of the motion, related filings, and arguments raised during the hearing, defense motion is denied without prejudice. Whenever they say without prejudice, it means you can refile that application. So we need to come up with a new basis for why it would be refiled. Like, it's hard for me to imagine the situation where this would be brought up again, but let's see. Defendant Trump seeks dismissal of counts 1 through 32 of the superseding indictment on the ground that statutory phrases unauthorized possession relating to the national defense and entitled to receive appearing in 18 U.S.C. 793 are unconstitutionally vague as applied under the facts presented, in violation of due process and the rule of lenity. So as you're aware, rule of lenity is whenever something is confusing, you're supposed to rule in favor of the defense and dismiss the charge. Although the motion raises various arguments warranting serious consideration, the court ultimately determines, following lengthy oral argument, that resolution of the overall question presented depends too greatly on contested instructional questions about still fluctuating definitions of statutory terms, phrases as charged, along with at least some disputed factual issues as raised in the motion. This is very vague. Resolution of the overall question presented depends too greatly on contested instructional questions about still fluctuating definitions of statutory terms and phrases as charged. So we're fluctuating, we're not sure what these statutory terms mean, along with at least some disputed factual issues as raised in the motion. For that reason, rather than prematurely decide now whether the application 18 U.S.C. 793 in these circumstances yields unsalvageable vagueness, that you have no chance of winning, and given dismissal, despite the asserted judicial glosses, the court elects to deny the motion without prejudice, to be raised as appropriate in connection with jury instructions, briefing, and other appropriate motions. So she basically is saying it's a little premature for us to assume that this is irredeemably vague. And accordingly, it is hereby ordered and adjudged defendant Trump's motion to dismiss counts 1 through 32 based on unconstitutional vagueness is denied without prejudice. So that's why she says without prejudice. She's like, look, at this stage, it's possible that the government can salvage these claims. It really depends on what evidence is presented and how determinations about certain statutory phrases are going to come up. So I need to she's basically saying, I'm denying it for today, and I'll sit on it and allow you to resurrect these claims in the future. So it's not really a win for Smith. It's perhaps potentially a forestalling. But it's definitely not a win for Trump. It's pretty much being held in abeyance until we get more facts and determinations of law. So I'm sure Trump was hoping to get this knocked out, but this is not really a loss. It's not a loss in the sense of like these charges as they are presented are good. You're going to face these charges. So I don't think it's a terrible loss. Not a terrible loss at all. All right. Is there any chance the Florida case gets thrown due to an arbitrary enforcement? Unlikely. Good question. And by arbitrary enforcement, what Penny here is referring to is that, you're enforcing these laws only against the government. It's only enforcing these laws against Trump, not enforcing them against Biden or Pence or various other officials. So that could theoretically be a claim that would be made by defense. There are always bases to try and say that there's a very clear distinction between them. So I wouldn't count on that. I don't think there's any sort of realistic chance of that being successful. Just being realistic. All right. Let's talk about Elon and Don Lemon. Our final story of the week. And by the way, I'm going to give you a heads up. I may end up doing a live stream tomorrow. Assuming that the decision of Judge McAfee breaks early enough, there is a small possibility that not even small, I'll say a 30 to 40% possibility that I will do a stream early tomorrow afternoon, probably around 2:00 or so. So if the McAfee's ruling drops, let's say before noon, good chance that I will do a stream tomorrow. And you're probably saying, how am I going to know how am I going to find that out, Joe? I need to get your breakdown as to what he's ruling. It's hard to figure out exactly how you would get a notification about me dropping a stream on you. I might recommend that if you want to get notification, that you can subscribe. That could be on YouTube. It can be on Rumble, wherever works best for you. You want to go subscribe, you just run on over and just jump up and hit that button, subscribe. I'd be most obliged if you did. If you don't, in addition there too, because sometimes these platforms can be a little bit wonky. If you sign up at goodlogic.locals.com, that's goodlogic.locals.com, you can be assured that you'll get notifications. As long as your notifications are on, you can be assured you'll get notifications of everywhere I am at all times. It's almost like you can be like my mother. Joe, where are you? I don't understand. What happened to you? Where are you? What's going on? Where are you? What's happening? It's my way of checking in with you guys. That's a goodlogic.locals.com. So, but barring that stream, final story of the week is right here. And when the week, I am in a week on Fridays. I'll be here Saturday night, hopefully. Don Lemon says Elon Musk canceled his deal with X after tense interview. Don Lemon, worst journalist in the world, 7 years running. Don Lemon says Elon fired him. Don Lemon said Wednesday that his partnership with Elon Musk went down in flames, which, let me tell you something, everything around Don Lemon is always in flames. Hours after the former CNN anchor conducted an interview last week with the erratic billionaire for the debut episode of his new independent web-based show. One show, and you're fired. Adios. Quote, Elon publicly encouraged me to join X with a new show, saying I would have his full support, Lemon said in a statement, adding that he took Musk at his word that he was interested in working directly with diverse voices. In an interview with CNN's Aaron Burnett on Wednesday night, Lemon spoke about his exchange with Musk and shared video excerpts from the 90-minute sit-down in which Lemon asked Musk questions on an array of topics. But why don't we watch that interview here? She's looking good as always. Okay. There she is. Even better. Okay. Let's get to it. Let's get to it. Big fail for Lemon not dropping this after posting the interview with Elon so he'd get people looking it up. Yep, because he's stupid. He's stupid. He should have announced that he was fired right after it got dropped, and this way he gets the ratings for it. He gets all the rewards. You share it on YouTube, go get your freaking rewards. Here's a link to the interview that got me fired. 5-inch sheet equals 1 ream equals 2.04 inches. 73K is 24 feet 11 inches. That was well done. Thank you, Salty. All right, let's check out what he's telling CNN.
Elon Musk tells Don Lemon, quote, contract is canceled, end quote. Now, in a moment, I'm going to speak exclusively with Don Lemon, and he has clips of the nearly hour-and-a-half interview with Musk.
Am I going to watch that interview? Oh, yes. Oh, yes.
Clips like this one that we received from Don's production team.
Don, the only reason I'm doing this interview is because you're on the X platform and you asked for it. Otherwise, I would not do this interview.
He's so blunt. Because frankly, I think you're boring and a waste of my time.
So you don't think? Do you think that you wouldn't get in trouble, or you wouldn't be criticized for these things?
I'm criticized constantly. I could care less.
We're going to have more clips from Lemon's interview with Musk in a moment. In a statement earlier today, Lemon writes in part, quote, there were no restrictions on the interview that he willingly agreed to. We had a good conversation. Clearly, he felt differently. His commitment to a global town square where all questions can be asked and all ideas can be shared seems not to include questions of him from people like me.
What the hell's people like me? What the hell's people like me? You mean morons? Is that what people like me means? You mean race-baiting morons? Maybe. Maybe. People like me. It's such race-based crazy-ass morons. Apparently he doesn't value our opinions.
Now, CNN reached out to X for their comment, and their response is, quote, we reserve the right to make decisions about our business partnerships. And after careful consideration, X decided not to enter into a commercial partnership with the show. Now, this decision coming as Musk had, of course, publicly courted Lemon and has repeatedly made a commitment to free speech when he bought.
Publicly courted Lemon? Did he publicly court Lemon? Where do we get that? See, you have to fact check everything CNN says because they're just purveying lies all the time. So I want to see here. Musk asks Lemon. I'm going to Google that. Did I miss where that whole courtship happened? Did he take him to movies? Did he buy him dinner? I'm seeing all these headlines. Musk scraps X partnership with Don Lemon. Look at these headlines. Oh yeah, Elon's big mad. Elon's big mad. Elon Musk tells Don Lemon where he's leaning in. Okay. Elon Musk. The search I made was Musk ask Lemon. I just wanted to see it because if he's courting, there should be some courting. Mad over Don Lemon interview. Don Lemon says Elon Musk cancel deal. Business Insider. Of course he bowed. It's what he does. Why did Elon Musk fire? They hate Musk so much. They hate him so much. They're so triggered. We're gonna have to deal with MDS, Musk derangement syndrome. Don Lemon's show canceled. Where did he court him? I guess we're just supposed to take that as a fact because she said so. All right.
On Twitter again and again, courted Lemon and has repeatedly made a commitment to free speech when he bought Twitter again and again and again.
You see, she's so bad at this She didn't even realize that the sentence that was written for her didn't end where it ended. So I'm just going to point this out just so you can appreciate how crap these CNN journalists are. Listen to her, the way she says that.
Repeatedly made a commitment to free speech.
She thought that's the end of the sentence.
And he bought Twitter again and again and again.
Well, I think it's very important for there to be an inclusive arena for free speech where all, Twitter has become kind of the de facto town square. Free speech is meaningless unless you allow people you don't like to say things you don't like. Otherwise, it's irrelevant. I really can't emphasize this enough. We must protect free speech. And free speech only matters, it's only relevant when it's someone you don't like saying something you don't like. It's damn annoying when someone you don't like says something you don't like. That is a sign of a healthy, functioning free speech situation.
Again and again and again. And
Okay. What does that have to do with Don Lemon having a contract with X? Was Don Lemon banned from X?
remember, Musk's X has over 250 million daily active users.
Gets them so mad. So mad. So mad.
250 million people on this planet resolve it. Use it. It is the town square.
Oh, thank you for finally recognizing that. Now they're finally saying that. For years, all we heard was build your own Twitter, build your own Twitter, build your own Twitter. Why don't you build your own Twitter? Oh, it is the town square? Oh, okay.
And joining me exclusively out front is Don Lemon. So Don.
Just because he believes in free speech, that doesn't mean he needs to like move in with the guy. That's got nothing to do with free speech. Like literally nothing at all. This is what the left has zero comprehension as to what free speech means. It's like whatever they want it to mean tomorrow. That's what or they'll change their minds every 15 minutes is what free speech means. This is like the reason, it's free speech for you to basically frame stuff in the crap way you frame it and make your audience stupider. That's what you do. You make your audience stupider. Why would X have to continue a contract with a guy who's a race-baiting lunatic like Don Lemon? I mean, it took him long enough to notice it, but...
You do this 90-minute long interview with Musk. You sit down with him. This is the culmination. He had actively courted you to come on one of his tweets. Have you considered doing your show on this platform? Maybe worth
he was asking to do it on the platform. You're still allowed to do it on the platform.
a try. Audience is much bigger. It had been public. Then you had reached a deal. I'll talk about that later. Then he texts 24 hours after this 90-minute long interview, which is the first of your show launching. He says, contract is canceled. What happened?
Yeah, so meaning he promised to give him money for doing the show on there. And then he basically said, no, you can't.
First of all, it's good to see you, Aaron.
I've missed so many people at CNN. Please bring me back. Please bring me back. It's so good to see you. I'm sorry I was such a jerk when I was here. I'm really sorry. It's so good to see you. I remember this building.
Thank you for having me on. That's a good question for Elon Musk. Quite frankly, what happened? I don't know. No. As I said in my statement, I felt really good about the interview. I said to him as we were doing the interview, and it was tense at moments, but you've been involved in tense interviews. Yep. I said to him, I think it's good that people see folks like you and I who have different worldviews come together and talk, as he says, have free speech. Free speech.
But we don't know. We need to see the rest of the interview.
Speech is only important when someone you don't like, or I would say someone who doesn't have your same point of view, or someone is, if they're allowed to speak freely and to say their point of view. Apparently that doesn't matter to Elon Musk. It's just...
Who says that that's why he fired you?
For maybe talking points for him or rhetoric, because it doesn't seem to matter when it's about him, questions about him from people like me.
All right. So when you said that, I wanted to play some of the clips because some of them are illuminating.
But these are select clips that he's giving us as opposed to the entire interview. Show us the entire interview, Don.
These are clips that you shared with us. This is a part of the conversation with Musk where you ask him about hate speech. Here it is.
Hate speech on the platform is up. Do you believe that X and you have some responsibility to moderate hate speech on the platform?
The last time he was asked that, he was like, "Really? What have you seen? Where's the, what's how's it out? What is hate? What is hate speech? What is?" He didn't ask that, but I would ask, "What is hate speech?"
That you wouldn't have to answer these questions from reporters about the Great Replacement Theory as it relates to
I don't
Democrats,
have to answer these questions.
the Great Replacement Theory as it relates to Jewish people. Do you think that?
I don't have to answer questions from reporters.
It's not a Great Replacement Theory. It is real. It's not a theory. It is real. When you're bringing in 15 million people, that's real. But that's not anti-minority. That's not anti-minority. If there were white folks coming in here, it would still be replacement of the citizens of America. So yeah, that's replacement. It's not the Great Replacement Theory. It's Great Replacement Plan.
Don, the only reason I'm doing this interview is because you're on the X platform and you asked for it. Otherwise, I would not do this interview.
So you don't think? Do you think that you wouldn't get in trouble or you wouldn't be criticized for these things?
I'm criticized constantly. I could care less.
Illuminating in so many ways. All right, I have two things I want to ask you.
What do you take from it? What do you take from it, honey?
About that, Don. First, the Great Replacement Theory. Right. As you bring it up, he has tweeted a tweet he shared: increasing illegals boost Dem voting power, causing them to recruit more. Mm-hmm. If Dems win President, House, and Senate, they'll grant citizenship to all illegals, and America will become a permanent one-party deep socialist state. Right? He has gone there directly. How much does he stand by these ideas?
Well, he didn't quite.
What do you mean? How much does he stand? How is that wrong? What part of that is? What part is inaccurate?
Seem to understand that he did originally. He did that with Jewish people. The Great Replacement Theory thing that he did with Jewish people, and he got in trouble.
Oh my God! Oh my God! Just stop it! Just stop it! Just stop it! I'm sorry. I don't need your freaking white knight for me. Okay? I don't need you white knighting for me. I don't need you to simp for. Oh, stop it! Stop it! Because you're not white knighting for me. You're not. That's not what it is. You're not white knighting for any Jews at all. For a single Jew, all you're trying to do is virtue signal that you're a good person and try and use any way possible. You're trying to contort as if there's some wrong that's being committed for the purposes of strengthening your own platform. So you're basically trampling on the very people that you purport to be standing up for. You're trampling them, using them as your tool for your own self-aggrandizement. That's all this is. That is all this is. And is gross. What you're doing here is racist, because you're basically trying to use Jewish people as a basis to say, I'm standing up, I'm white knighting for Jewish people, when you're not helping a single Jew anywhere at all. I'm standing up for Jewish people. I'm going to use that to take down my political opponents. This is why you're fired. This is why, because you're gross and disgusting. I take offense from you and the way you use Jews a billion times. I take no offense from anything that I can't say a billion times, because that implies I take some offense from what Elon Musk said, because it's a multiplier of some level, and there's no level of offense from what Elon Musk said. The only offense is coming from this jackass over here who's trying to white knight for Jews.
When he had to go to Auschwitz and answer questions and apologize and go with Ben Shapiro. But he doesn't understand that sort of rhetoric that he talks about, the Great Replacement Theory and migrant invasion. That's what radicalized shooters use in their manifestos.
Which shooter? The trans shooter? Which shooter? What are you talking about? Who are you talking about? What the hell are you talking about? He radicalized. You radicalized. You radicalized tons of people with your stupid race-based ideologies. You're the one who's radicalizing people. Idiot.
Those exact words. The people who go and shoot up people, whether they be Latino people who live in Texas, or black people who are in a supermarket in Buffalo, or Jewish people who are worshiping, those people use the same rhetoric, that they are tropes.
What the hell are you talking about? I don't even know what he's talking about.
that they're either racist for Latinos or Black people or for Jewish people. And I wanted to know if he felt any responsibility as
who, which person? Gosh, who's the dude that you're standing up for?
someone who has one of the largest social media and information platforms in the world.
250 million people.
A 250 million people. I think
they love saying that. They love saying that. Now all of a sudden it's the town square.
455 or 500 million users a week. And it doesn't seem that he feels that he has any responsibility with that because he seemed really averse to facts.
Here's another clip.
You're averse to facts. You're the one who is sitting here saying that this is offensive to Jewish people. You see, you're averse to when it's not. I mean, yeah, sure. I guess if you talk to the crazies, Jonathan Goebbels of the world, who's, you know, standing up for the ADL, yeah, they'll pretend because they're looking for their own stupid power. They don't care. They don't care about defending Jews either. This is so gross. This is so gross.
Talked about ketamine in this particular instance, something that he has discussed before. Here he is.
You talk about your ketamine use and depression. You also have said, and
the reason I should say, the reason I mentioned the ketamine prescription on the X platform was because I thought maybe this is something that can help other people. That's why I mentioned it. Obviously, I'm not a doctor, but I would say if someone has depression issues, they should consider talking to their doctor about ketamine instead of SSRIs.
Yeah. Very civil conversation, but that is where it got very personal.
Well, it got personal, but I didn't put that out there. He has spoken very freely about his use of, those are prescription drugs, but about his use of ketamine. I would not have brought it up if it was
on X, he posted it.
He posted it.
Yeah.
And so I would not have brought it up because that's someone's personal information. So I asked him about it. Also, it's no secret. His drug use, or alleged drug use, I should say, has been extensively written about it by very credible news organizations like the Wall Street Journal. And I asked him that, and he said, listen, I have not read the Wall Street Journal. I don't read the Wall Street Journal. If I don't have time to read about everything that people write about me, I would never get anything done. But also, we remember on Joe Rogan, he took a puff of marijuana, right? And he said it was just a joke, and I only took one puff. Elon Musk is responsible for satellites, for Starlink. He's responsible for Tesla.
So
he's responsible for a number of different companies on the stock market.
Yep.
And I think that it is important for people to understand his mindset, whether he's using drugs legally or not, and even if
trying to get him on marijuana use. Where does Rogan film? I'll bet anything that marijuana use is legal there. Where is Joe Rogan's studio? I bet it's in California. It's in LA. It's totally legal. Loser. It's such a loser. What the hell are you even talking about?
the ones he's using.
He's
that's
one of the
supposed to
most
be
powerful people on the planet.
But that's what he's one. But
so what the hell's that to do with anything? So he can't smoke a blunt because he's worth $60 billion? Who cares?
But ones that he's supposed to be, that he is using prescription-wise, that he's following a doctor's orders under that.
Mm.
But yes, he's one of the most consequential people to the planet. And that was one reason why I was attracted to X.
In this conversation, you did talk about Trump. And again, given his role, it's one of the most powerful people in the world, running X, who he is going to support, whether he donates, the meeting that he took at Mar-a-Lago is of huge consequence in the context of everything that he tweets.
Oh, so now he's not allowed to be political because he has money. Oh, no. So where was your examination of Mark Zuckerberg on that? His whole Zuckerbucks and motivating Democrats specifically to run. Where was that?
And here's part of the conversation you had with him about Trump.
Losers.
You recently met with Donald Trump in Florida. What did you guys talk about?
I was at a breakfast at a friend's place, and Donald Trump came by. That's it.
What did you discuss?
I don't. Let's just say he did most of the talking.
Did he ask you for money?
He didn't.
Are you going to loan him money to help pay his legal bills?
I'm not paying his legal bills in any way, shape, or form.
Did he ask you for a donation?
No.
Are you leaning towards anyone?
No.
You're not leaning towards anyone because you've been.
I'm leaning away from Biden.
You're leaning.
That's great. That's great. Let me get a couple of these chats before we finish this up here. Don Lemon looks like he has AIDS, looking like he does look terrible. He looks terrible. He could have just gotten old. Could be that. Who knows? Fanny's running for re-election and said she felt giddy. She's sure she's going to win. I don't know. I don't know. It is free speech. Don Lemon is still on Twitter. Just no contract show. Sorry, your show sucks so bad. Cancel after one show. Yeah, exactly. His show is terrible. His show's terrible. You had me on it. You did such a terrible job. Though I'm like, nah, I got no interest in paying you money anymore. Jenny L. Jenny. Musk likes lemonade. LOL. I see what you did there. I see what you did. I see what you did. Culmination was on first show. Great start in. It was congratulations on you. Dear Don Lemon, congratulations on your first and last show that you're getting paid to on X. Your first and last. That's great. Joe, how can Bragg prosecute Trump when Cohen took upon himself to pay Stormy without Trump's knowledge? That's a question of fact. We don't know that he didn't have knowledge on it. If he can establish that he didn't have knowledge of it, in that case, that would likely be a factor. And if he learned about it after the fact and then didn't record it the way he would have to, that could theoretically still hold him to be culpable. Because it's not the payment itself; it's how it was recorded. That's the issue. So that's what the left would respond to you if you want to know the legal answer they would provide. That is a legal answer they would provide. But I think these charges are bunk for 1,000 different reasons. Don can hear the dog. Oh, he hears every dog whistle. He's really good at the dog whistles. I hope Musk did his own recording of interviews. Don will cut it up. Remember, Don thinks black holes can swallow up planes. Maybe a black hole swallowed up. Did he say that? I forgot that. That's pretty funny. Lemon thought if he tore down Elon enough, CNN would take him back. That might have been it. I hadn't thought about that. S. Dasp says, I saw a response to Musk saying Lemon's style was too much like CNN, and CNN is on its way out, a loser, and Musk didn't think he's a good fit for X. That would make sense. It's pretty funny.
The trademark laugh there, which, by the way, in the context of the contract is canceled 24 hours after that interview, it just shows there was a lot of back and forth and give and take.
I'm not showing you them. Sorry. Yeah. I don't know what the hell she's talking about now. Yeah, there could be give and take. That doesn't mean he doesn't think he sucks.
What did you take away from his comments on politics?
Well, he says he's not going to endorse anyone now, but he may do it later. He says he's not going to give money to anyone now, but he may do it later. You never know with him. He may, be endorsing someone now on the platform. But, what's interesting to me in all of that and all these questions that, about what people are asking me, what I asked Elon, what happened, what did I do?
Yep.
During the course of that interview, I never raised my voice. I told him, I think this is important for people to hear, especially considering how the type of discourse.
The problem is that what you think is important for people to hear is basically race-baiting messaging, and that's something Elon doesn't seem to think is important for people to hear. That's your problem. You're in disagreement about what's important for people to hear. So you're giving your opinion, but Elon thinks your opinion is stupid. That's really what the problem is here.
Having in the country right now. And he supposedly says this is a public square for all. Maybe we're learning that a public square should not be privately owned by someone who doesn't think that there should be any moderation on that platform. So it was interesting because at the end, I could tell that he was upset. He was uncomfortable. It was tense. And I said, listen, I'm not trying to make you uncomfortable. As a matter of fact, I would go and have a beer and hash these things out. You and I do not disagree. You and I do not agree on much.
Yeah.
But I will fight for your right as
the party
to be able to say what you want to say. That's what freedom of speech means to me.
No.
And 24 hours later, then.
And 24 hours
You won't fight for that right. That's crap. You won't fight for that right.
later.
The
It
text
means
comes.
freedom of speech does not mean, I guess, the same thing to him as it does to me.
Elon
It
Musk
doesn't mean anything to you. That's crap. You won't fight for anyone's right for free speech. When were you fighting for anyone's right for free speech before Elon bought the platform? When were you fighting up about all the abuses of conservative voices that are being canceled? Where were you fight? Where was you in the? I don't remember seeing you in the fight for that. You'll fight. You're so full of crap. You're such an utter liar, Don Lemon. You're such a complete and total fail. I'll fight for their right. Give one example when you did. For something that wasn't your fight is exclusively looking at things through a race-based lens designed to sow further and further division. And Elon Musk saw through it. He saw through you. And now you're pretending that this has something to do with free speech rather than you being canceled for being an utter failure, which you are. So, with that, my friends, we come to the end of another week. Concert LD says, "Imagine that makes the boss mad and get fired." He's so bad. Don sucks and sometimes blows. I think he's probably doing both at the same time often. All right. That is our show for the week. Like I said, good chance I'll do a stream tomorrow. If McAfee's decision comes out early enough tomorrow, good chance I will do a show tomorrow. Good chance. But we'll see. We'll see what's going to happen. Also plan on being laid back law. So you can find me at goodlogic.locals.com. I'm going to be kicking over to my good friend right now. Wishing you all the very best weekend. If I don't see you, if you don't see me, if we don't see each other, if somehow we miss each other, please make sure you like and subscribe. 30% of you are not currently subscribed. That must be remedied. So make sure that you like and subscribe, whether you're on Rumble, whether you're on YouTube, whether you're on X. Even you X folks, I want to suck you into the void here too. The void with all the cool cats. So hope you have a phenomenal weekend. Make sure that you stay happy. One way you can stay happy is make sure that you do not under any circumstances eat the bugs. And as always, my friends, probably true. As always, my friends, I say to you, thank you so much for your time, your patience, your patience, your appreciation, and your support in every way that you have. Have a good night and Godspeed.